State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Buckle up, guys, because today's courtroom drama is a masterclass in bad decisions. Our star? A self-proclaimed sovereign citizen who decides she's smarter than the entire legal system. From the moment she fires her lawyer before a probation violation hearing, you can feel the tension building. The judge's face says it all. This is about to get messy, and we're just getting started.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
No.
All right, guys, here's where the train starts leaving the tracks. The judge calmly asks why she's firing her attorney, but instead of a reason, she gives vague excuses. When reminded she'll have to follow the rules, she brushes it off like they don't apply to her. The court warns her self-representation is risky, but she waves it away. That's the moment you know this hearing isn't ending well for her.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes. And I did. I received that. And apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
Now it gets interesting. The judge gives her an easy out, admit to the violations and move on, possibly with a lighter outcome. But no, she insists on fighting. With that single decision, she opens the door for the prosecution to roll out every violation on record. It's like watching someone walk willingly into quicksand, completely convinced they can float.
All right. Do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor, I do not.
All right. Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument.
Here comes the hammer. The probation officer takes the stand, and it's a laundry list of failures: missed appointments, failed drug tests, new charges. Each point is a nail in the coffin, delivered calmly and professionally. The best part? The judge is just sitting there, letting it all sink in, while you can practically see her case collapsing before your eyes. This is the moment the outcome becomes inevitable.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
And just when you think she might try to fight back, she does absolutely nothing. No cross-examination, no questions, no evidence, just silence. The judge offers her the floor, and she declines like this is optional homework. In courtroom terms, this is the equivalent of throwing in the towel before the match even starts. At this point, it's not a matter of if she loses, but how badly.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Closing arguments hit hard. The state lays out a clean, bulletproof case. She violated terms repeatedly and showed no intent to change. Then it's her turn. What follows is a jumble of sovereign citizen buzzwords and unrelated tax code references. It's almost surreal watching her argue points that have nothing to do with why she's in court. The gap between reality and her version of it is staggering.
Alright guys, that's the end of the video. As it turns out, having a public defender is way more effective at ensuring your freedom than representing yourself and doing nothing at all. So if you liked the video, leave a like. If you disliked it, leave a dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.
Here's the grand finale. The judge reads out the violations in full and revokes her probation, sentencing her to serve time. But instead of taking it in, she explodes, ranting about rates, codes, and conspiracies while officers move in. It's the perfect example of courtroom patience finally running out. If you enjoyed this breakdown, make sure to hit that like button, subscribe to the channel, and we'll see you in the next video.